Greetings, everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Fernanda Suriani, and this is the second panel of the fourth day of the event. I'm very glad to be here with you. Before starting the panel, in the name of ICAIL organization, I'd like to thank our platinum sponsors, JUS Brazil and Albert Einstein Israeli Hospital, our gold sponsors, Logarithm, Legal Code and PG Lawyers, and our silver sponsors, Urbano Vitalino Lawyers, Opsi Bloom Lawyers, and Oasis Open. Now, I would like to introduce Mr. George Borges, who will present the full paper with the title AI Systems and Product Liability. Mr. Borges, you have 20 minutes of speech. Afterwards, we'll move to the questions, and the stage is yours. Welcome.
Thank you very much, and good morning or good afternoon, everybody, depending on which part of the globe you are. AI systems and product liability. Did I share my screen? Not yet, I guess. I prepared some slides, which are hopefully visible now. And it's my subject, AI systems and product liability. Just let me move on, just to make it clear, I'm professor of law. I'm not technician, I'm lawyer, and this presentation is on legal aspects of AI systems. So I'm not going into detail of technical aspects. It's about the law regulating the technology in this case. What is the role of liability within the legal framework for AI systems? Let me briefly introduce. AI systems give rise to enormous expectations. We think that the world will be brighter and richer once we are establishing a framework, a coexistence of humans and AI systems in some future. However, at the same moment, there are some risks associated with AI systems. And the most striking example, which made it clear to the world, maybe was the Uber car accident 2 years ago, when a self-driving car was running over and killing a pedestrian. I'm sure you're aware of that. Another aspect of risks associated with AI systems are machine-made decisions, which is often linked to the questions of algorithmic fairness or machine bias. In this case, very often a machine is making a decision which has an effect on humans. For this presentations, I will not deal with the second group. I will deal exclusively with the risk associated to physical harm and damage caused by AI systems, such as machines like self-driving cars and others. AI systems pose a very specific challenge to the legal systems, as AI system can show what I would like to refer to as behavior. Of course, any machine can function, but what is different between function and behavior? Just as a working definition, I would define behavior in this meaning as the ability to choosing actions depending on a perceived situation, which a traditional steam machine 200 years ago could not do, but a self-driving car would have to do at any moment while it's functioning. This is a challenge to the laws, as behavior or choosing action is an ability which was attributed to humans only, not to machines. And the legal system is not prepared to a machine showing its own behavior. It's not surprising that liability is in the core of the legal discussion for an adequate legal framework for AI, at least in Europe. From 2018, the European Commission was active in this field, starting, for instance, with the communication of 2018 AI for Europe, where a good deal of the paper was dedicated, surprisingly, to questions of law, in particular liability. The next, as a step, I want to refer to the work of an expert group on liability and new technologies, which was established by the European Commission in 2018 and delivered its final report in December 2019. I will refer to this as the expert group made the conclusion that some amendments of the current legal framework are needed, in particular, the introduction of new rules on liability. The European Parliament took the opportunity in October 2020 and suggested the introduction of a civil liability regime for AI systems, in particular including a proposal for regulation on liability of operators of AI systems. And most recently, the European Commission in April 2021 published its proposal for the so-called AI Act. The AI Act is a very, as it's demonstrated by its title, a suggestion which introduces fundamental principles for the use of AI systems. By substance, however, it mainly restricts to the introduction of the duty to establish a risk management systems by operators and producers of AI systems. It does not refer to any liability rules, since these rules will be dedicated to a specific insurance for liability for AI systems. We expect the first proposal by the European Commission to be published in fall this year or spring next year. I want to talk about liability in the AI system. So what are the functions and concepts of liability? This is very important to bear in mind when we talk about the detailed questions. The traditional function of civil liability is to offer compensation for damage occurred. However, a second and possibly even more important function of civil liability is that it creates incentive to the addressee of liability to adapt his behavior, for instance, driving carefully in order not to be liable. When we talk about concepts of liability regimes, we should distinguish between the traditional fault-based liability, which is known worldwide in every jurisdiction which I'm aware of, where liability depends of the existence of a breach of a duty of care. You're only liable under fault-based liability if you breach a duty of care. As a contrasting concept is well known, the concept of strict liability, which exists in a huge number of variations. Basically, the idea of strict liability is that the addressee of liability is obliged to pay damages whenever a damage occurred within a defined sphere of risk. Just to give an example, under many jurisdictions, the operator of a car will be liable to pay damages whenever an accident occurred while operating the car. This is a very easy example of strict liability. The sphere of risk is the operation of the car. And these rules are very important for AI systems as well. The last aspect of the conceptual framework of liability certainly is to whom the liability is addressed. In the current discussion, there seems to be a trend on introducing new rules on strict liability of the operator of an AI system. So the basic idea is that the person being obliged to compensate for damages should be the operator of an AI system. Regarding the producer of the AI system, many authors and legislators refer to the existing framework of product liability. And that's why product liability is so interesting for our questions, since this is, at this moment at least, dedicated as serving also to or dealing with the challenges posed by AI systems. The legal framework of product liability is different, obviously, in all jurisdictions. in particular, US law played a very important role in the development of product liability rules. However, in my presentation, as I'm European and in particular German lawyer, I would like to refer to the system of the European product liability, which is applicable all in the European Union and is similarly known by the basic concepts in many other jurisdictions worldwide. The basic rule of the product liability directive is set forth in this Article 1. The producer shall be liable for damage caused by a defect in his product. So there's liability for any damage caused by the product if and only if the product is defective. So the defect of a product is the main reason or source of liability. Please keep this in mind. I will come back to this in a minute. Now, the question is, how can we apply product liability directive to AI systems? It goes without saying, and is not disputed at all, that cyber physical systems, which is a functional unit of hardware and software like self-driving cars, robots, and so ever, are products within the meaning of the product liability directive. It is still somehow disputed, or there's still some uncertainty as to the question in how far software which you can download from the internet can be considered as a product within the product liability directive. Most authors nowadays consider software being a product, and we expect an amendment of the product liability directive, which is announced for next year, which will probably expressly include software into the regime of product liability. This is an important step, as for the past 30 or 40 years, many people were thinking product is never error-free, so software should not be subject to strict liability, but that is state of, or will be probably be state of the art within a few years from now on. When it comes to AI systems and in particular systems which use machine learning to develop their function, the question arises in how far a neural network, or let's say the functional unit of a neural network and the software to run it, can be considered as a product. But obviously, if software is a product, also the functional unit of software and the data model has to be considered as a product. For this reason, all kinds of AI systems which are in place will be subject to product liability under the European scheme. The next question is, who is the producer? Who is the addressee of liability? And this is the producer of the AI system according to Article 3 of the PLD, as we call it. The producer is addressee of liability is the producer of the finished product, but also the producer of any raw material or of a component. So if software is a product, in most cases a component, this programmer of such software will be producer and can be liable under the PLD. In the case of a neural network, which gathers its abilities or functions by training, as we know, the person who is conducting that training has to be considered as a producer for the simple reason that the neural network only acquires its functions or abilities via the training, and the training process which is initiated or steered or conducted by a person, that has to be the producer. To sum up, we don't have any difficulty in applying the PLD on AI systems, including systems which are based on machine learning, and we don't have any difficulty to make liable any person who is responsible for the functionality of such system or software. Now I would come turn to the most difficult question, in my view, with regard to AI systems and product liability. As I said in the first part of my presentations, AI systems have the characteristic that they can show what I would like to call conduct or behavior. In this way, they're different from traditional products. A defect is defined as an insufficient property of a system. So we have to refer to the properties of the system and check if they are fulfilling the expectations or not. Insofar they are below the reasonable safety expectations, the product is to be considered as defective. So in the case, however, how can we apply that systems to an AI systems? Again, the self-driving car offers a simple example. If a self-driving car is running flawless for 1 million of kilometers or even miles, is it defective if it causes an accident in the 1 million and first mile? This example makes it clear, in my view, that conduct or behavior of a system is not per se a property of the system. We should and have to distinguish between property and conduct. However, a kind of bridge between conduct and property can be established if we assume that the ability to behave in a certain way in a given situation can be considered as a property of the AI system. So the property, which is the reference point for defectiveness, is the ability of the system to behave in a certain way.
5 more minutes, Mr. Porteous.
Excuse me?
5 more minutes.
That's exactly what I expected. Thank you so much. So product, just to make it short, is not a liability for faulty behavior. And this is important since we have to establish this ability. The next question, and in my view, most difficult question, is what is the reference point for the conduct? If you refer to the ability to conduct or behave in a certain way, what is the reference? Is it human behavior? So far, the legal framework doesn't offer any answer to this, since the legal rules were designed for humans, not for machines. Certainly, human capability can serve as a first orientation for safety expectations to AI systems. You should certainly expect that a self-driving car would behave similarly than a human driver, for example, would respect traffic signals or so. However, obviously, there's no limitation by the expectations are not limited by the reference of human capabilities. You definitely can expect a self-driving car to use the brakes much faster with a faster reaction than a human driver. It makes it clear that we need a kind of independent expectations for machine, which are designed to the capabilities of machines and not just apply the rules which have been designed for humans. And the next question is, what is the accuracy? In this conference, as in general, when we develop AI systems, we are proud of accuracy of our tools. But what is the accuracy which we have to expect from an AI system? Can we expect an error-free AI system? Can we expect that it will always, in any future situation, behave correctly? Is that the test? Is it 100% error-freeness what we have to demand? Certainly not, as this would be a liability for behavior, not for an ability. That makes it clear that we have to find out what the fault tolerance in case of an AI systems is, and it's obvious that this depends very much on the risks associated with such systems. You would probably expect a higher accuracy from an airplane or self-driving car than from an AI system which is supporting a lawyer in searching decisions or arguments. And the next question, the next challenge then is, how can we assess that the system fulfills the safety equations, the error, the required accuracy? And this goes via testing. That's why testing of AI systems play a major role in the concepts of liability for AI systems in the future. Proper testing can also be a safety expectation of the product itself under the PLD already. So even if you apply the common, the present legal system, testing can be part of it. The last point I want to mention is the most important one in practice very often, that's the burden of proof. Under the PLD, the injured person shall be required to prove the damage, the defect, and the causal relationship. So the burden of proof is on the victim. Under most legal systems in Europe, we don't have any tools to support the victim in collecting the facts. And even if we had some kind of pre-trial discovery, it is very difficult to establish the fact. For this reason, the expert group, which I mentioned earlier, is suggesting the shift of a burden of proof and say in certain situations. The expert group did not clarify under which circumstances such shift of a burden of proof should be in place. So the crucial question then is, what are the conditions for such reversal of the burden of proof? I would like to suggest a solution which I described in my paper, which is that the reversal of the burden of proof for defectiveness of a product should be in place in the case of faulty behavior of such product. So once we can establish that the AI system behaved in a given situation in a wrong way, the reversal of the burden of proof that the product as such is not defective shall be on the producer. To conclude, product liability can in general be applied to AI systems. One of the main challenges is what is to distinguish between conduct or behavior on the one side and the property of the system on the other side. However, we can bridge this by considering the ability to behave in a certain way as a property. There are two main challenges in my view. The one is the definition of the expectations regarding the accuracy of an AI system to behave properly. And the other one is the proof of a defect, the burden of proof of a defect. And here I would like to suggest to introduce a shift of the burden of proof for defectiveness in the case of faulty behavior. And that's it. Thank you very much for your attention.
Thank you, Mr. Borges. It was very interesting. Actually, there are many concepts of law that are being challenged by AI, and this is definitely one of them. We have a question from Mr. Adam Weiner. Actually, he is asking you to comment about the development of these issues in the UK and USA, if possible.
I'm not familiar with the recent developments in the US. In the case of UK, which was part of the European Union until very recently. So in the past, it has had the same rules. And of course, the PLD is still current legislation in the UK. So all I said for the current situation refers to the UK as well.
Okay. Another question from Marcelo Lopes is, if product liability law can be applied to situations involving discrimination or otherwise unfair assessments by AI systems, what could be done to encourage producers to avoid biases in their systems?
Thank you very much for that question, which refers to my next presentation. It's a very interesting one. To cut it short, in my view, testing is the answer also to fight against bias and discrimination, since the big advantage of AI systems compared to humans is that we can reproduce their choices. So they are open to testing. Even though there are limits to testing, just to give an example, it's hard to reproduce the Uber accidents, since there's so many factors and so many potential data which you cannot never really re-establish. Also, if you consider that an AI system would assess a person based on a video interview, the amount of data makes it very, very hard to do just exactly the same. So even though there are limits, testing is the very big advantage which we have when it comes to machine-made decisions compared to human-made decisions.
Okay, good. Francesco Sovrano is asking, what if it's not possible to assess a defect nor a lack of defect?
What if it's not possible to assess a defect?
Nor a lack of defect.
If you don't know if it's defective or not, in that case, there is no claim for damages. So the victim has to establish the existence of a fact, and if the facts do not allow the judge to assess that there was a defect, the case will be dismissed.
Okay, and can you have some comments about the Teubner ideas of you give a personality, legal personality for AI systems for liability issues?
Thank you very much for that far-reaching questions. As we know, the idea of a legal personality, which was brought up by the EU Parliament in 2016 and discussed worldwide after that, has not found many friends in most Western countries. In Europe, it was Estonia who showed a sympathy and announced some legal action, but later refrained from it. And in most scholars in Europe strictly oppose the idea of legal personality of AI systems. Surprisingly, in other areas of the world, there is more openness to this. When I have a frequent exchange with Japanese colleagues, and interestingly, the colleagues in Japan were much more open to the idea of giving personality to AI systems than their European counterparts. So it is very interesting to see that even though intuitively a European lawyer would certainly reject the idea of attributing legal personality to machines, like I would do actually, we have to consider to see that the idea is not, it's not impossible to conceive legal personality. Certainly what we will need is an idea of addressing machines in their behavior. I hope I could make it clear in my presentation that conduct is not a property and that we have to deal with a system, a machine, which is behaving similar to, in its own way, but similar to a human who is also choosing his action in a given situation. And that point is just not addressed by the current legal system. And if that is an idea which you can take away from my presentation, I would be very happy.
Yeah, actually, it's a very, very interesting point of view. I really like it. Thank you very much, Mr. Borges. Now, I will introduce you. Sorry, do you have any more comments to finish? Any?
No, thank you. That was my closing remark already. Thank you very much.
Thank you very much. So next, I will present you to Francesco Sovrano, who will present a short paper called A Dataset for Evaluating Legal Question Answering in Private International Law. Francesco, please, the stage is yours. Welcome.
Thank you. Thank you very much. Do you see the slides?
Yes, we can see.
Okay, that's great. And so, okay, I'm going to present this paper of ours that's a data set for evaluating legal question answering on private international law. And okay, so why private international law, first of all? And that's the first question I'm trying to answer. The answer is that this is a complex legal domain, as you are aware of. And that presents frequent conflicting norms between a lot of legal sources, a hierarchy of legal sources, legal domains, adopted procedures, and so on and so forth. So it's quite complex to be able to somehow handle all these different information, all this information. And so legal experts in this case have to access heterogeneous sources to apply hermeneutics, and also they have to possess a deep understanding of legal language. And at least this is clear to me, not being a legal expert at all. I'm more computer science. So when I try to read some kind of legal source, I always struggle to sometimes disambiguate the meanings from natural language to legal language, in a sense. Anyway, so hermeneutics is still an important aspect to be aware of when analyzing these legal sources. And so reasoning over private international law is quite challenging, especially if it's automated reasoning, and especially when regulations change frequently or are big enough in size. And so even for a human can be daunting in some cases because of the differences, the subtle but clear and strong differences between jurisdictions and the sources. And so here we go to our research question. So the idea is that we identified this being a challenging challenging aspect to tackle, a challenging problem for artificial intelligence. We are interested in providing automated answers to questions written by legal experts for extracting information out of private international law legislative texts. And so this is kind of challenging, according to state of the art, at least. And so the first point is to be able to evaluate such a tool, any kind of tool for automated answering to these questions. And properly evaluating requires the identification of a data set, an evaluation data set. And this was the very first, let's say, step we had to take in order to consider, in order to develop any kind of automated question answering tool. And so this is why we are focusing today with this paper. We are focusing on this kind of on a data set, and because it's mandatory for any kind of tool for the evaluation, proper evaluation. So we improved over our previous work using a larger and more curated data set on private international law, and we published that work on Jurix 2020. And we decided to extract the data set out of the 3 regulations European Union from the European Union, and these are Rome 1 regulation that's on the law applicable to contractual obligations, Rome 2 regulation that's on the law applicable to non-contractual obligations, and Brussels 1 bis on jurisdiction and the recognition and enforcement of judgments in civil and commercial matters. So
2 more minutes, please.
Sure. So the target of our tool is the practicing lawyers with reasonable yet not expert knowledge of private international law. And so this dataset is clearly going to be a set of questions and answers, and expected answers for that questions. And these expected answers are in the form of articles, recitals, or commission statements, if any. In this case, we decided to consider recitals beside articles because the user persona could be interested in prima facie interpretative tools. And so we followed a methodology for building the dataset. So we asked to 5 legal experts to be involved in this, and so 2 of them selected the questions, trying to not be speculative or trying to be agnostics to elements that are placed outside the regulations. While other two independent experts tried to find a set of expected answers using only the information within the regulations. And they had to avoid interaction with each other. And after this process, we had to merge the answers given by the two legal experts because there were subtle divergences between them. And so we used a third legal expert to do that, disposing of a higher level of expertise. And so furthermore, we also classify the questions according to a heuristic we called context specificity. And so we labeled questions as highly specific when the answers were exactly in the domain of the regulations. And normally when they were falling just in part within the scope. And otherwise, low specificity was given to the question. After the process, we had 17 questions, and of them, particularly 1/3 of them had a low specificity, 1/3 a normal specificity, and 1/3 a high specificity. And we also try to evaluate the data set in a sense using a tool. So we try to understand the behavior of existing tools on the new data set. And so we took the one from our previous experiments, the one mentioned before from Juris 2020. And the expectations were that the QA tool, the question answering tool, was likely to not perform well on questions with low specificity because supposedly they require multi-hop reasoning, and that tool was not equipped with that capabilities. And so this is a screenshot of the tool. So you see the question and the answers. After the evaluation process, we got the scores, and we grouped them by questions specificity. And we observed that the expectations were somehow met because we saw that the F1 scores increased proportionally to the context specificity. And that's quite reasonable because the specificity of the question is low when it asks something that is not closely related to the regulations. Multi-hop reasoning is usually required to answer questions with low specificity, but the baseline was not equipped for that, as we said. And so, as example, this question, how should a contract be interpreted according to this regulation? This has a very low specificity. Because it probably requires to pinpoint both recitals and articles for a proper answer, and so therefore more distinct and distant paragraphs, and so requiring multi-hops in the regulations, in the knowledge graph at least, the underlying the regulation. And so our belief is that most of the speculative questions would require broader view on the subject matter, having a low specificity to the regulations, therefore requiring multi-hop reasoning. So this paper, this dataset should help us in the future to evaluate properly new algorithms, to understand whether they're failing to different tasks, because question answering is probably involving different tasks. It involves answering to questions with a low or medium or high specificity. And being able to disentangle them could be beneficial for evaluation. And so we extended our previous work presented during Juris 2020, proposing this larger and more curated data set for the evaluation of private international law, of questions on private international law. And that's it. So I think I finished. Thank you for your attention.
Thank you very much, Mr. Francesco Sovrano. We'll have a question for you. And at the third section of your paper, when you talk about context specificity, you say that multi-hop reasoning is usually required to answer questions with a low specificity, but the baseline is not equipped for that kind of reasoning yet. What are the main challenges to make your model able to answer this type of question?
Oh, no, okay. Yeah, it's quite challenging, especially in this context. If you look at state-of-the-art question answering tools, especially applied to legal knowledge, they always try to handle single or two-hop reasoning questions. It's very challenging to go farther, in a sense. But I believe that one of the process, one of the ways to go could be to integrate this question answering tool that is mainly based on deep language models, to integrate this tool with external reasoning tools. They are designed to handle multi-hop reasoning questions, in a sense. So the point here is that we have natural language, and that's quite good for deep language models. We have formal reasoning tools that are not capable of handling natural language. So the challenge is to be able to, as always, in a sense, to bridge the gap between natural language and formal languages. And I believe that with the tool we are providing, we are using as baseline, this is possible by extending the knowledge graph, in a sense, the underlying knowledge graph that is used to answering questions, with new information coming from these reasoning tools. And that could be possible by, I don't know, using some discourse theory or some, by analyzing the language, the structure of the language and the information within the language in a proper way by means of existing theories of language, natural language, such as discourse theory or argumentation theory or so on. So I believe that this could be possible in a sense to, just to approximate some proper, let's say, level of multi-hop reasoning. I don't know, it's open, it's still an open problem for us.
Perfect. Thank you very much, Mr. Francesco. Do you like to address some more final comments?
No, I think unless there is any more questions.
Not yet. Actually, we have a delay, so maybe some more questions will come, but not yet. So thank you very much. And next, I will present you to Mr. Fernando Esteban de la Rosa, who will present a short paper called Making Intelligent Online Dispute Resolution Tools Available to Self-Represented Litigants in the Public Justice System. Mr. Fernando, the stage is yours. Welcome. We can see it. You can go on. You are muted. Okay.
Now,
yes.
Thank you very much. First of all, I would like to thank the organizer for such a great organization of this conference. Thank also for allowing me to present this contribution together with my colleague, John Selesnikov. He's a regular at the association's conferences, not me, in this case, it's my first time. I come from the University of Granada in Spain, where artificial intelligence and law studies are being enhanced through a research unit created in 2018 named Digital Society, Security and Protection of Rights. This is an open research unit aiming to promote joint research initiatives, especially with researchers belonging to this association. This is the name of my of our contribution today is making intelligent online dispute resolution tools available to self-represented litigants in the public justice system. Our contribution focuses on the technological changes being made to justice systems to support the vulnerability of self-represented litigants. This situation of the self-represented litigants is becoming more and more frequent and is increasing in both common law and civil law justice systems. The aim of this presentation is first describing the use being made by some jurisdictions of combined ODR and AI tools for self-represented litigants, and second, to promote the debate on the ethical governance of making these tools available to self-represented litigants. To this, we will follow an European approach. The point of departure, is that ODR, online dispute resolution, is moving more and more from ADR to courts. ODR allows users to appear in court on their own without legal assistance. ODR allows the users to file a claim, to follow a case, to negotiate with the other party, to have the intervention of a mediator, and also to have a hearing through video conference, telephone, face-to-face. But it is possible to move a step forward, and some jurisdictions have begun to provide justice users with intelligent user-centric ODR systems incorporating information and assessments AI tools, diagnosis AI tools, and predictions tools. The important thing is that this is in order so that disputants can be better prepared to deal with a direct negotiation conducted online with the aim of enabling the dispute to be resolved without the need for a court ruling. We have some examples stepping forward. Here we have the Dutch platform Rechtsbeheer, where the parties are informed of rules such as those for dividing property, child support, and standard arrangements for visiting rights, so that they could agree on the basis of informed consent. Also, we have the British Columbia Civil Resolution Tribunal. The CRT is the most significant current widely ODR system that comes closest to providing a full suite of dispute resolution services. It offers the diagnosis of the dispute by providing an expert system decision tree and provides legal information and tools such as customized letter templates. Between 2017 and 2018, China has also created 3 new internet courts in Hangzhou, Beijing, and Guangzhou. These courts only have jurisdiction over internet-related cases. Litigation risk assessment aims to help the party without legal knowledge to identify and exclude common litigation risk, thereby reducing unnecessary losses. Meanwhile, the assessment can make the party aware that litigation is risky and costly and guide the party to choose ADR or diversified dispute resolution. The system can automatically generate a complaint letter by simply selecting the suitable response options. There are also interesting projects in Estonia and Singapore. For instance, Singapore is developing an ambitious online system, initially only for injuries arising from motor vehicle accidents. An outcome simulator will provide guidance to potential claimants prior to the commencement of the proceedings, helping them to decide on offers from insurance companies. The aim is for parties to first use the technology to reach amicable settlements without professional legal advisors. In order to give an answer to the situation of the self-represented litigants, the justice system should be adapted to support them. Some of the facilities refers to the use of AI tools. The system should allow users to enter information, ask them for appropriate data, and provide for templates to initiate the dispute. The system should provide information on how important it is to act in a timely manner and where to send the dispute. But the system should also provide tools for reality testing, both article reports of cases, copies of legislation, and videos, and the most important thing, the possibility of having information about best alternative to a negotiated agreement in order to promote the direct settlement.
5 more minutes, please.
Okay, sure. Communication tools are also important. Decision support tool, if the disputant cannot resolve their conflict, software using game theory or AI can be used to facilitate trade-offs, and drafting software is also important. In Europe, there is a concern about ethical issues and government related to AI. It is well known, the European Ethical Charter on the use of AI in judicial system and their environments. but we have also documents in the field of the European Union, like the opinion of the European Economic and Social Committee, the Digital Revolution in View of Citizens' Needs and Rights, the White Paper of the European Commission on Artificial Intelligence, the resolution of the European Parliament with recommendation to the Commission on a framework for ethical aspects of AI, the communication from the Commission called Digitalization of Justice in the European Union, and finally, the most important document today is the proposal for a regulation laying down harmonized rules on artificial intelligence. The position of the European Ethical Charter is clear. It's admit that there are inherent risks in these technologies. These tools could create a new form of normativity. The report is skeptical about considering this compatible with the individual right ensuring in the European Convention of Human Rights, fair trial, the right to an independent and impartial tribunal. So it's not clear this compatibility. The position of the European Commission is a little bit more open. It's considered also that the proposed requirements in the white paper on increased transparency, human oversight, accuracy, and robustness of the systems aim to facilitate their beneficial use while ensuring that fundamental rights, including non-discrimination, based on sex, racial, ethnic. So it would be possible to respect the due process principles. And the position of the new proposal for regulation is open, but it's not completely clear. So it is make a separation between both possibilities of using AI. But at the end, the decision would be in the hands of the states. We submit that neither the recent official documents of the European Union nor the Ethical Charter on the use of the AI in judicial system and the environment deal directly with the admission of AI tools aimed at enabling the party to assess their legal position. Because self-represented litigants generally lack legal skills, and in view of the objective to encourage negotiation, we submit, John and me, that this issue of technology for this purpose should be considered high risk. However, in view of the beneficial impact of the functioning of the judicial system, it is necessary to identify the technical limits and the safeguards to be met by the machines offered by the public justice systems to self-represented litigants. From this point on, the need arises to find out what information should be provided, which technology should be used, and what safeguards need to be put in place. But this is the topic to another conference. Thank you very much for your attention, and John and me, we will pleased to answer the questions.
Thank you very much, Mr. Fernando Esteban de la Rosa. It's a quite interesting subject. Well, I have some questions for you, and actually it's taking from your conclusion. So what are your suggestions of safeguards to enable the use of AI by judges and at the same time avoid bias against minorities or the development of rule of law, meaning the evolving interpretation of the law? For instance, the case Brown against Board of Education in US, if it was based on AI, all those best precedents, past cases, maybe it would be an impact to evolve the interpretation of racism in US. So that's the question.
I must say, I'm sorry. Can I start on this? Yeah, I mean, Brown versus Board of Education is something I've written a lot about. It's an incredibly important case because the basic premise was, in 1896, the Supreme Court of the United States in Plessy versus Ferguson said segregated schools are okay as long as they're equal. In 1954, in Brown versus the Board of Education, they said we have observed over the last 58 years that segregated schools are not equal. So we can't allow segregated schools. Now, the basic point coming out is that AI should never, you should not have robots making decisions. And none of us are actually arguing that. It has got to be the human judge that makes the decision, but the AI can help the human judge make much better decisions. The AI can also be transparent. You can look at the way, often judicial decision-making is not transparent. With computer systems, you can look at how they reached a decision, and if you're not happy with the process, you can undo it.
Do you want to answer as well, Fernando? No.
Only to say that the possible measures in order to control, to submit to control, it depends on the technology used. But because one thing is to develop an expert system that is a question of programming, and other thing is using machine learning. It's completely different. Indeed, it is important to decide which is the technology, the best technology in order to offer information to the self-represented litigants, because of the different functioning of this technology. So, but for instance, for expert systems, that I probably would say that it is better to use expert systems than technology of machine learning in order to inform users. Maybe it would be possible to use some of the recommended in the white book of the European Commission, like concerning possible testing of application and the need to provide relevant documentation on the purpose and functionalities, maintaining the possibility to correct errors and providing information to users that the answer given by the machine may not necessarily match the answer that would be given by a judge hearing a case. All of these are causal measures that it could justify the use of this kind of technology.
Okay, another question. You said that the self-represented litigants push the limits of judges' impartiality, and that ODR tools may overcome this issue. In your opinion, the fact that the court provide information like the British Columbian Tribunal in such a way that the parties may obtain a prediction of the outcome, even though meant for the preliminary stage of direct negotiations conducted online, can also affect court's impartiality, in the sense that this prediction may cause a machine bias.
Well, I might say nothing is ever unbiased. We all have social, political, cultural values. Now, the whole idea of, you know, self-represented litigants have always been at a disadvantage compared to those people who get good professional advice. So having contacts, having money is always a benefit in any system. What we're saying is that the use of online dispute resolution systems and systems to support litigants in ADR is going to improve their chances. It's not going to make it equal, it's not going to make it perfect, but it will provide opportunities that have not been previously available.
And do you think AI, in a sense, in the system, the justice system, how can we avoid the machine bias? I mean, all the prediction, all the drafts or the propositions made by the system that is thought as more neutral, can it happen? How we can manage the safeguards? Do you think it's only to use not using in the justice system the learning machines, only expert system? Is there a solution?
It won't be perfect, but there are human biases that what we're, that's the whole legal profession, and certainly the legal academic profession. What we're trying to do is to improve it. And the one way to bias is to make everything transparent. And what I'm arguing is that the legal system has generally been a mumbo jumbo, which non-professionals don't understand. Technology, particularly expert systems, rule-based systems, is going to help you understand this process.
Perfect. I totally agree. The user-centric technology using to simplify all the complexities of the justice systems will be a great advantage for the vulnerable ones. Thank you very much. And well, now we'll have a short, do you have any final comments? John, especially because, no, okay. So thank you very much for your participation in ICAIL. And now we'll have a short break for 30 minutes. And those who want to meet other participants and exchange experience can access the GatherTown platform for a networking moment. The link is at the OpenFi platform. Thank you very much and see you soon.
Thank you.
Thank you.